Public comment. Thank you very much. Good afternoon, Ms. Mullins.
Good afternoon, sir.
All right, no cases to reconsider under agenda item 3.
Correct, no cases.
Let's consider tax liability cases under agenda item 4. I believe we have 3 tax cases on docket 48.
Yes, sir, there are 3 cases. The first is case number TD-22-02-0722. Commissioner Demerson,
Agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
and Mr. Chairman.
Agree with staff recommendation.
The second case is TD-22-025-0822. Commissioner Demerson,
Agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
and Mr. Chairman.
Agree with staff recommendation.
And the final case is TD-22-028-0622. Commissioner Demerson,
Agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
and Mr. Chairman.
Agree with staff recommendation.
Thank you.
No fair housing cases under agenda item 5.
Correct, no cases.
Agenda item 6, we have no wage claim cases pulled for additional discussion.
That's correct. None pulled for additional discussion, but you should have received the wage claim short form dissent list for docket 48.
I move we accept staff recommendations on the remaining wage claim cases on docket 48.
I second the motion except for those cases on which I'm dissenting as reflected on the wage claim short form dissent list for docket 48.
And I concur with the chairman's motion, except for the cases on which I'm dissenting, as reflected in the wage claim short form dissent list for docket 48.
Motion passes with the exception of second amendment.
Thank you.
Let's move to agenda item 7, consideration of unemployment insurance cases on docket 48. Please proceed when you're ready.
Case number 2925589, Commissioner Alvarez.
The decision is not supportable. The claimant filed for benefits because he stopped driving for a ride sharing company and had heard others who had done the same had been eligible for benefits. He did not understand the unemployment claims are not filed against specific employers. When he received his statement of wages and potential benefit amounts, he realized it included wages from his current employer and immediately contacted TWC. The claimant has provided evidence that he submitted an appeal on April 14, 2020, informing TWC that he believes that there has been a mistake in explaining the situation. TWC continued issuing payments despite the claimant's appeal. The claimant's actions were clearly not an intentional, willful misrepresentation or non-disclosure of material fact, but simply due to the lack of understanding over the area of law. These circumstances do not rise to the level of fraud, of a fraud act. Reverse AT, no fraud, and recompute overpayment based on the unreported earnings.
The AT decision is supportable. During the weeks for which he was claiming unemployment benefits, the claimant was working full-time and earning substantial wages. Despite the clear instructions on the claim certification forms, the claimant failed to report his work and earnings. Although he may have had questions about his base period wages, that did not justify failing to report his work and earnings on the many different claim certifications he submitted. Accordingly, we should affirm the AT decision. The claimant committed fraud, overpayment of $4,168.
Modify the AT forfeiture provisions not applied. Affirm the earnings adjustment overpayment.
Just to clarify, we'll recalculate the overpayment in accordance with that vote. Thank you. So the majority vote is no fraud. Yeah.
In short form dissent.
Yes, sir.
Okay, thank you.
Case number 3179220, Commissioner Alvarez.
The decision is not supportable. As stated in the case number 2925589, the circumstances did not rise to the level of fraud under the act. The claimant misunderstood the law regarding unemployment insurance. The claimant notified TWC as soon as he realized there was an error. Modify the AT, timely appeal, no fraud, and recompute overpayment based on the unreported earnings.
Just as with the companion case, the AT decision in this case is supportable. I agree that the claimant's appeal to the appeal tribunal was timely. During the weeks for which he was claiming unemployment benefits, the claimant was working full-time and earning substantial wages. Despite the clear instructions on the claim certification forms, the claimant failed to report his work and earnings. His questions about his base period wages did not justify failing to report his work and earnings on the many different claim certifications he submitted. Accordingly, we should affirm the AT decision. The claimant's appeal was timely. The claimant committed fraud, overpayment of $12,504.
Modify the AT timely, the claimant appeal forfeiture provisions not applied. Affirm the earnings adjustment overpayment.
Is the majority still fraud?
Yes, no fraud, readjust the overpayment.
No problem. Short form dissent.
Yes, sir.
Thank you.
Case number 2517812, Commissioner Alvarez.
The AT3 decision is correct on the issues of timeliness of the petition to reopen and good cause for the non-appearance at AT1, correction AT2. The claimant did not receive the notice of telephone hearing for the AT2 hearing, nor the AT1 decision. I do not dispute the ruling on good cause for the non-appearance at the AT1. However, based on the merits before AT1, the claimant should not be disqualified. The employer stated in its response to the notice of claim that the claimant was on reduced hours due to COVID. They gave the same information in a different piece of correspondence sent to the commission. TWC records reflect wages reported by the employer paid to the claimant in the second quarter of 2020, which was smaller than the prior quarters. This corroborates their statements that the claimant was on reduced hours due to COVID. The preponderance of the evidence establishes that the claimant was involuntarily separated for reasons that did not constitute misconduct connected with the work, and his hours were reduced due to the pandemic. Modify the AT3, timely petition to reopen, good cause for the non-appearance at AT2, no good cause for the non-appearance at AT1, no misconduct, no chargeback due to disaster, and void adequate response.
The appeal tribunal decision should be modified. I do not contest the issues of the timeliness of the claimant's Rule 16 petition to reopen, nor the issue of the claimant having good cause for missing the AT2. With regards to missing AT1, the claimant provided the commission with an incorrect address, which did not give him good cause for his non-appearance. As to the underlying job separation, the weight of the credible evidence establishes that the claimant requested leave time from the employer without a return to work date due to concerns about COVID. Since the claimant requested leave, which was granted, but did not provide the employer with a return to work date, he quit voluntarily without work-connected good cause. We should therefore modify the AT decision. The claimant filed a timely Rule 16 petition to reopen. The claimant had good cause for his non-appearance at AT2. The claimant did not have good cause for his non-appearance at AT1. Voluntary leaving, no chargeback. Sever the validity of claim and adequate response issues.
Modify the AT, timely petition to reopen. Claimant established good cause for AT2. Claimant did not establish good cause for AT1. No misconduct, no chargeback, disaster, void adequate response, sever validity of claim.
And Commissioner Alvarez, the chairman's vote agrees with yours substantially. He also severs the validity of claim issue. Didn't catch that part of your vote. Is that what you said?
I didn't say it, but I'm going to say it now.
Very well, sir.
Mhm.
Thank you.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 3065452, Commissioner Demerson.
Commission should conduct a rehearing. In this case, the employer in its testimony and through its file documents submitted to the commission alleged that the employer had daily unfilled vacancies for substitute teachers. Since the employer is a base period employer, as opposed to the last employing unit, the record needs to be further developed on whether the claimant was working a substitute teaching assignment on the day she filed her initial claim. The circumstances of this case, the fact that if the claimant was working an assignment on the day she filed her initial claim, there would be no job separation. However, if the claimant was not working an assignment with the named employer on the day she filed her initial claim, there would have been a separation with the named employer that would need to be examined. Indeed, the employer witness stated that there were days the claimant did not accept work. To reach a proper resolution in this case, the commission needs to determine whether the claimant was working a substitute teaching assignment or otherwise performing services for pay with the employer on the day she filed her initial claim. As such, we should conduct a rehearing to clarify this point and also to enter the employer's additional documentation into the record.
The AT decision is supportable. The claimant was not discharged for misconduct connected with the work, and the claimant did not voluntarily leave without good cause connected with the work. There is no basis for protecting the employer's reimbursement account. Affirm the AT decision, bill reimbursing employer.
Reverse the AT, reimbursing employer not.
The chairman's vote again.
The chairman is reimbursing employer not billed.
I agree with the chairman.
Okay, majority vote reimbursing employer not billed.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Yes, ma'am.
Case number 3133917, Commissioner Alvarez.
The AT decision is correct. During the meeting on January 20th, 2022, regarding the statement the claimant made in December of 2021, the claimant asked if his last day, the claimant asked if it was his last day and put his badge on his supervisor's desk. He never surrendered his badge. He picked up his badge, stated that he was not resigning, and returned to his office. No reasonable person could interpret the claimant's actions as a resignation. One of the employer's witnesses, who was present during the meeting, agreed that the claimant merely asked if it was his last day and made no expression of resignation. 30 minutes later, the supervisor came to the claimant's office and stated that the employer was accepting his resignation, despite again telling his supervisor and the senior HR director that he was not resigning. The employer escorted him from the building. The claimant did not resign. He was clearly discharged. The employer has not provided evidence of misconduct, and the claimant's questioning of whether he was employed is not misconduct. Affirm the AT, no misconduct, and bill reimbursement employer.
The appeal tribunal decision should be reversed. The employer stated that the claimant tossed his ID badge across the table and said that there may very well make it his last day. Moreover, the claimant made an inadequate attempt to clarify his job status, and his actions left the employer with the reasonable impression that he had quit his job. As such, the claimant quit without work connected to good cause. We should therefore reverse the AT decision, voluntary leaving, reimbursing employer not billed, adequate employer response.
Affirm the AT, no misconduct, bill reimbursing employer.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Case number 3137583, Commissioner Alvarez.
The decision is not supportable. The claimant tested positive for COVID-19. She contacted the employer and provided documentation of her positive test. The claimant remained in contact with the employer, but was never able to get through to HR. She asked what she needed to do and received no course correction and received no response. The employer did not appear at the hearing and has not provided evidence to establish misconduct. Since the claimant's separation was a result of a disaster, I can agree to protect the employer's account. Reverse AT, no misconduct, no chargeback, MBI.
The appeal tribunal decision should be affirmed. The claimant was asked to provide specific documentation to the employer to substantiate her COVID test results. The claimant did not submit the documentation. The employer stated in file documents that it needed the specific documentation because the test results that the claimant submitted could have been from anyone. By not complying with the reasonable employer request, the claimant mismanaged her position of employment. We should therefore affirm the AT decision, misconduct, no chargeback. In the alternative, if my fellow commissioners do not agree, we should modify the AT decision. The testimony from the claimant appears to support a finding that the separation ultimately stemmed from the claimant being ill due to COVID. As such, I could also support a vote of no misconduct, no chargeback, MBI.
Affirm the AT, misconduct, no chargeback.
Chair, I'm going to agree with the chairman on that vote.
Majority vote is misconduct, no chargeback.
Short form dissent.
Thank you, Commissioner Alvarez.
Yes, ma'am.
Case number 3227144, Commissioner Alvarez.
The AT decision is not supportable. On March 21st, 2022, the claimant was being harassed and cursed at by field chief. She told him to stop, to which he replied, if she did not like it, she could leave. That day, the claimant called two managers in her chain of command to report the harassment, and that the field chief told her to leave. One of the managers advised the claimant that she could not return to the job site and that there was no longer any work available at the time. For the next 2 weeks, the claimant kept in contact with the employer asking about available work, but the employer did not respond. After 2 weeks, the employer texted the claimant that her services were no longer needed. The employer has not refuted any of the claimant's testimony or evidence. The claimant did not voluntarily leave her last assignment. She was discharged for reasons other than misconduct connected with the work after she reported harassment by a field chief. Reverse AT decision, no misconduct.
We should affirm the appeal tribunal decision. The claimant quit due to dissatisfaction with the employer's working conditions. Although the claimant alleged discontent with her supervisor, the records show that the claimant never expressed her concerns until her last day of work. In addition, the record further shows that the claimant quit based on an ambiguous statement by her supervisor about the status of her job. Since the claimant quit without affording the employer an opportunity to resolve her concerns, and because the claimant failed to clarify the status of her job upon leaving, the claimant did not establish good cause connected with the work to quit. Hence, we should affirm the AT decision, voluntary leaving.
Affirm the AT voluntarily.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3231967, Commissioner Dimerson.
We should modify the appeal tribunal decision. The claimant was terminated for violating the employer's workplace violence rule by striking a coworker with a pizza pan. The claimant was previously counseled for misbehaving at the workplace and was advised that further infractions could result in termination of employment. Since the claimant was counseled for his behavior, but thereafter violated the employer's workplace violence rule by engaging in a confrontation with a coworker, the claimant's conduct was mismanagement of his position of employment and was misconduct connected with the work. Hence, we should modify the appeal tribunal decision, misconduct, no chargeback, sever the adequate employer response.
The AT decision in this case is not supportable. The claimant was discharged due to an altercation with a coworker for which the coworker was not also discharged. The claimant put a pizza pan on a table the coworker was sitting at. The coworker threw the pan on the floor in response. The claimant then picked up the pan and tossed it back onto the table. While the coworker alleged that the pan hit him after the claimant tossed it back on the table, the claimant and another witness denied that the pan hit the coworker, and the video evidence was inconclusive. Based on the available evidence, coworker was at least as culpable for the incident, especially since he initiated the confrontation by throwing the pan on the floor. Since the coworker was not also discharged, the claimant was not discharged for misconduct connected with the work. Reverse AT, no misconduct, chargeback, void, adequate response.
Reverse AT, no misconduct, chargeback, void, adequate response.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Case number 3270260, Commissioner Alvarez.
The decision is not supportable. On October 10, 2021, the governor issued Executive Order GA 40, which prohibited entities in Texas from compelling receipt of a COVID-19 vaccine to individuals who object for religious, medical reasons, or any other personal conscience. After the governor's order, the employer decided to implement a COVID-19 vaccine mandate. They did not allow an exemption for any reason other than personal conscience as required. The claimant, a teleworking employee, requested an exemption based on her teleworking status. The employer denied the claimant's request and instead canceled her teleworking agreement. The claimant met with the employer several times, and the employer admits the claimant sought an exemption related to her personal conscience. The claimant was told she could request a medical exemption, religious exemption, or get vaccinated. She was fired on April 2022 for not being vaccinated. Since the claimant's discharge was not in compliance with the governor's order, the claimant should be qualified for benefits in the employer billed. Reverse AT, no misconduct, bill employer, void, adequate response.
We should modify the appeal tribunal decision. The claimant was separated when she failed to adhere to a workplace policy implemented by the employer. Since the employer's testimony insinuates that the purpose of the policy was to promote safety at the workplace, the claimant's violation of the employer's policy was the equivalent of misconduct connected with the work. Hence, we should modify the AT decision, a misconduct, reimbursing employer not billed, sever adequate employer response.
Reverse the AT, no misconduct, bill reimbursing employer, void, adequate response.
In short form dissent.
Yes, sir, Commissioner Dimerson.
Sure. Why is the count short form dissent on the reimbursement issue? I failed to add that here.
Case 3270260.
That's correct. Some short form dissent would do it on the reimbursement issue.
Okay, yes, sir. I have it. Thank you.
Case number 327 5662, Commissioner Dimerson.
We should grant a rehearing in this case. The claimant was discharged for cursing at a coworker and causing disruptions at work after prior warnings for similar behavior. In its appeal to the commission, the employer is offering to present firsthand witnesses to the claimant's actions. Such evidence is clearly relevant and should be considered before rendering our decision in this case. Accordingly, we should rehear this case for the employer's firsthand witness.
The decision is correct. The claimant is the only party to provide firsthand testimony. The employer discharged the claimant for causing disruptions, which the claimant has denied. The claimant complained to the employer about the behavior of another employee. That employee would loudly hum and sing in the office, throw papers at the claimant, and refusing to answer the claimant's work-based questions. Instead of addressing the issue, the employer gave the claimant a warning for being disruptive and fired her. The employer has not presented evidence of misconduct. From the AT, no misconduct chargeback.
Rehear.
We will rehear the case. And that was the last case pulled for additional discussion on docket 48. You should have received the UI short form dissent list for docket 48.
Move to accept staff recommendations on the remaining UI cases on docket 48.
Chairman, I second the motion, except for those cases on which I'm dissenting as reflected on UI short form dissent list for docket 48.
I encourage the chairman's motion, except for the cases on which I'm dissenting, is reflected in the UI short form dissent list for docket 48.
Motion passes with the exceptions noted.
Thank you.
Thank you. We're going to take the briefest of breaks while we reset for the rest of this meeting. For 2022 workforce awards.
Chairman, oh, there it goes.
Good afternoon.
Yeah, good afternoon, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, Mr. Cerna. For the record, I'm Joel Mullins with the Workforce Development Division. On September 28th of 2021, the commission approved objectively based monetary awards for workforce development boards, including the service to employer awards with the monetary award amounts of $100,000 for first place, $75,000 for second place, and $50,000 for third place. The calculation of the performance data to determine the winners of the 2022 Service to Employers Award has resulted in a tie for third place between two boards. Today, staff recommends budgeting an additional $50,000 in Workforce Innovation and Opportunity Act statewide funds for the Service to Employers Award to allow each third place winner to receive the full award amount of $50,000. And that's all I have, and I'm happy to answer any questions.
Any comments or questions?
No, thank you, Joel.
Not here.
Fair motion.
Chairman, I move that we budget an additional $50,000 in Workforce Innovative Opportunity Act statewide funds for the Service of Employers Award. So both third place winners receive the full amount as recommended by staff.
Second.
It's been moved and seconded, and we are in fact.
Okay, thank you.
This is agenda item 9, Child Care Local Match Report Contract Year 23.
Good afternoon, Chair Daniel, Commissioners, Mr. Cerna. For the record, Sandra Williams with the Workforce Development Division. The Texas Workforce Commission allocates child care services funding from the Child Care and Development Fund for local workforce development boards for a portion of the funding. Boards are required to secure and submit local matching funds to TWC in accordance to federal regulations and TWC Chapter 809 Child Care Services Rules and TWC Chapter 800 Administrative Rules. As noted in the discussion paper, the first BCY 23 match agreements are being brought forward for approval. Supporting documents include 14 match agreements from 5 workforce development boards, which are Central Texas, Coastal Bend, Dallas, Panhandle, and Texoma, totaling $3,051,059. Boards have secured 7.38% of the statewide child care local match target for BCY 23, with 3 boards securing at least 50% of their local match and 1 board to securing 100%. Staff recommend accepting the child care pledges for donations, transfers, and certifications of expenses for BCY 23 in the amount of $3,051,059.
Any comments or questions?
Thank you, Sam.
Not here.
Is there a motion?
Chairman, I move that we accept child care match in the amount of $3,051,059 for board contract year 2023.
Second.
Move it to second reading.
Thank you.
Thank you. Commissioner Demerson, it occurred to me too late that while Joel was up there, that while technically he has spoken before a commission meeting, it was never in this room. I think we might otherwise have asked. Next time. Let's see, I'm showing nothing on agenda items 10 through 12. Don't see that we're having a legislative report today. Mr. Cerna, an executive director's report.
Just a few brief items. First off, I'd like to recognize our board colleagues who have joined us for this very brief, interrupted their EDC meeting and joined us for this very brief commission meeting here in Dallas. So I appreciate that very much. Second, I will say that Julia and her staff have done outstanding in the preparations for not only the commission meeting, but the conference as well. And of course, we will discuss that and recognize that during the conference. I did talk to Lowell because staff was already asking me if I needed to authorize them to redo our commission meeting room to match this one, at least the color scheme. And I told them no, that we wouldn't be doing it. We didn't have the ceiling height for the chandeliers. So
Can we appoint a committee to look into it?
we might, maybe a commission subcommittee.
We'll work on it.
Okay.
Mr. Troman and I.
And then the last two things is just in case anybody is interested, since we are in here, the United States is leading Iran in the World Cup with a good deal. And then the very last thing is while several of our staff are here, I did want to assure the commissioners and everybody else that the majority of the staff is still it looks like there's a lot of people here and there are, but the majority of our staff are still at their offices or working from home, but they are still conducting the states and TWC's business. And a lot of them are still doing that from here too. So even though it appears that there are a lot of us that are here, things are still moving forward in case y'all were just kind of curious about that. That's all I had to
Very
report.
good. Thank you, sir. Is there any other order of business to come before the commission?
Chairman, I have a few remarks I'd like to make. So for those that don't know, for close to 7 years, I've been in this position. I had a conversation with Governor Abbott's office again this morning. And I just wanted to confirm with him and of course with you that are in attendance that I will be stepping down on December 15th of March. I mean of December. And so I thought it'd be appropriate that we would do this during the conference. It's been a pleasure to serve each and every one of you, the 14 million working Texans of this great state, and especially with the 28 boards that we have throughout the state of Texas. I mean, it's no wonder why everybody wants to do business with us because of the great people like you. When I started in 2016 with Governor Abbott, I knew nothing about Texas Workforce Commission. Matter of fact, when I got appointed, I was hoping it was DPS Commission because I knew about that. But what an honor it's been to serve with some of the greatest commissioners in this state of ours. And what a pleasure it's been to be able to represent each and every one of you. I mean, the ideas, the innovation, all the great things that have come to fruition have been because of the hard work that all of you all have certainly done. The ideas that have been brought forth by my office were from stakeholder meetings back in 2016, when we were able to travel the great state of Texas and listen to stakeholders. I'd be remiss if I didn't acknowledge that it's been a pleasure to work with the 28 boards. And then I know we have some new ones that are joining us. And then, of course, we have Linda Angel, who I always cringe because she has the same name as my ex-wife. So I just think that's funny. So I was cringe when I see her. But working with Ruth and Andres, who I sat back and I listened to for the time that they were here, I thought that was so beneficial for me to just step back and listen. And then, of course, the experience and the conversations that I had with each and every one of you allowed me to kind of express what we wanted to do. And everything from converting a vacant healthcare facility in Central Texas with the school district to the co-located educational specialist, you know, to the expansion of what we do for robotics with people with a disability, as we explained earlier this morning. It's just amazing what things we've done. It did take some time. As you know, my dad is 80, gonna be 81 in a couple of weeks. And I look forward to working and spending a little bit more time with my father. He's the only family that I got. So, as you know, I have a place in South Texas. Whenever I go down there, I like to stay with him and spend time with my father as much as I can. But I've been very fortunate that the governor had enough trust in me to pick a young kid who just lives 4 miles from the local border to sit in a position where I could represent the great people of Texas. So it certainly has been a great pleasure. But because I have many of you that are in this room, I'd also be remiss if I didn't acknowledge my great staff, from Jason, Brent. We just hired Holly, who has been a treasure to us. We have Elena, who we call the enforcer, because she makes sure that we're on time on everything. And then, of course, the addition of Jade, who works with us, you know, what a jewel she's been, with a smiley face that people walk into my office. But we all know who the real commissioner of my office is, and that's Jenna De La Cruz. And I'm super excited to have someone like her at my side. Everybody knows her. And I'm just very humbled that you all allowed me an opportunity to work with these two fine gentlemen that are sitting to my right. We may have not always agreed on things, but we certainly respected each other. And at the end of the day, that's what it's all about, is respect. And so I just want to thank all of you for the great work and for working so closely with my office and for being so innovative. So with that said, I will see you at the rest of the conference, but on December 15th will be my last day working for the Texas Workforce Commission. But who knows what's going to happen in 2024? I just thought I'd throw that in there, but we'll see what happens. But again, I look forward to working with you, maybe in a different capacity, but I continue. Like I said, it's been a pleasure to represent each and every one of you and to work closely with you. To my fellow commissioners, I wish you luck, and I have no doubt that whoever's in this position, you'll fully support. So thank you. Thank you.
Well, Commissioner, that certainly deserves a response. And this is what I'd say. You mentioned that we didn't always agree because we were never supposed to. We were supposed to come to the best answer for the people of Texas. And I do have to say, I have always felt like your motives were aligned with the interest of Texans and how they could really advance themselves. And that's why we get into public service. I mean, it's not for the rewards for ourselves. It's the reward that we get for helping people. And I certainly think you exemplified that. Thoroughly enjoyed working with you. On a personal level, we've had a great time in the brief time that I've been here. I know that our paths will cross many more times. Our economic development roots really, I think, go pretty deep. And I know that we'll have plenty of opportunities to work together. And I really look forward to that. It's been a joy and a pleasure to serve with you. Nothing's permanent in this world, and we always move on to the next thing. And it's an exciting time for you. And it's an exciting time to see kind of where your next path takes you. And I hope that we're on that journey with you.
Thank you, Chairman.
Chairman, I guess I was going to second the motion. Commissioner Alvarez says my voice is deep. I think it's the microphone here working, but appreciate the work. I call Commissioner Alvarez the Texas Tornado. Gave him that name a long time ago, and it was because of the work that he does and the way that he approaches a room and takes care of business in a big, big way. And so nothing new that I'm saying. I've always told you I admire what you do, the respect and the level that I have for you. I was privileged to work with you before becoming a commissioner and got a chance to experience the work ethic and what you were doing to make a difference at that seat level. And then working with you as a commissioner, we've been able to do some amazing things. Chairman mentioned we don't always agree, but I like to focus on those moments when we do agree. And we have agreed on a lot and have done a lot. And you have done some things that are legacy work. You're going to see the results of that. We're going to continue to see the results of that. The work that you've done on the leadership side, the work that you've done with the programs that a lot of individuals statewide, but particularly in the Valley, are receiving. I will never forget the work that was done with our JET program and high demand job training program and our TIP program in the results that we're seeing as a result of some of the things that you've done firsthand. I've been at that table to see that happen. And so commend you on that work. We'll miss you. We appreciate the work that's been done. This will, as the chairman mentioned, it won't be goodbye forever because we'll continue to make those rounds, but wanted to publicly just express my admiration and respect and appreciation for what you've done over the years to make a difference in our state. And you truly have done just that. So thank you for all that you've done.
Thank you, both of you.
Any other item of business?
No, sir.
Hearing none, is there a motion to adjourn?
Chairman, I move that we adjourn.
I'm in the second motion, but before that, Ed was saying the guys are back at the office taking care of business. I ran into Chris Nelson either yesterday or the day before. Chris was glad that you guys are all gone. So
I know he is. He thinks we're not spending money, but we're spending it just the same here.
he's the chief financial officer, and he basically said, no, they're going, I'll gladly stay behind in the light, but I second that motion.
It's been moved and seconded to adjourn, and we're adjourned.